Welcome back to Law and Crime. We're going to now pivot our cameras to the latest updates in the trial of Jeffrey Young Thug Williams and his co-defendants who are charged under the Racketeer, Influenced, and Corrupt Organization Act, also known as RICO. Prosecutors say rapper Young Thug is part of a criminal street gang known as Young Slime Life, or YSL, and that it's responsible for violent crimes in the Atlanta area ranging from theft to murder. But defense attorneys say their clients are not part of a criminal street gang, and YSL stands for rappers record label known as Young Stoner Life. Now, as you know, this case has been running for about 19 months now, and we have seen many changes in the courtroom. In case you missed it, the case now has a new presiding judge, Judge Paige Reese Whitaker. The first judge on this case, Gerald Glanville, was recused after his handling of an ex parte meeting with prosecutors and their key witness, Kenneth Copeland. And the second judge, Shakira Ingram, recused herself because of conflicts of interest. As Judge Whitaker gets acquainted with the case, attorneys were asked to file any pending motions so that when they reconvene next week, the judge will make rulings. And yesterday, a motion for mistrial was filed by defense attorney Doug Weinstein, the lawyer for Diamante Kendrick, aka Yak Gotti. In the motion, Mr. Weinstein accused the Fulton County prosecutors of intentionally triggering a mistrial to what the defense said is a losing case. This all goes back to a secret meeting that prosecutors had with their key witness, Kenneth Copeland, and former Judge Gerald Glanville. Yesterday, the prosecution also filed a motion not to be outdone for attorneys not to speak to the media as the case moves forward. And here to chat with us, we have the attorney for Yak Gotti, Doug Weinstein. You are so good to come on with us, and I want to ask you, why is it that this motion is filed for a mistrial yesterday, and what makes it novel?
Well, we had really no choice but to file for a mistrial. In this case, the prosecution definitely goaded us into this. They asked the judge for that meeting, that ex parte secret meeting, worked with the judge to keep it completely secret so that we didn't know about it. We were fortunate enough to find out about it. At that meeting, the judge and the state coerced Kenneth Copeland into changing from his decision to not testify into testifying. So there are any number of errors that happen that violate Mr. Kendrick's due process rights, his rights to a fair trial. So we had, look, we're winning this case, but we had no choice but to file a motion for mistrial.
So you sort of answered my next question, which how the ex parte meeting impacted the progress. But in terms of not only impacting the progress, how do you go back with a new judge and undo the issues that were created by the ex parte meeting with the judge meeting with Kenneth Copeland and the prosecutor alone, and then trying to put one of your co-counsels in jail?
You know, there is a lot that has to be undone. And it's just not doable. And let me just give you one example. When I filed the motion to recuse Judge Glanville on June the 12th, at that time, Judge Glanville should have stopped all proceedings in the case. Sorry about this truck going by. And referred the motion out to another judge to make a decision on that. He failed to do that. Instead, he continued to have testimony presented to this jury. Kenneth Copeland talked on the stand to this jury, testified for 4 days. And now, according to the law, we have to rewind the case to before that testimony. How can you rewind the case? How can the jury unhear 4 days of testimony? It just can't be done.
Yeah, and let me go following this up. The prosecution then files a motion yesterday to say you, the whole group of defense attorneys, cannot speak to the media when they have tried this case and made speeches, I think, in the courtroom that were really geared towards the media publication of the speeches. Talk to us about that.
Yeah, that's right. And by the way, my apologies. I should have started this interview out with giving a big shout out to ADA Love and ADA Hilton, because apparently they are watching our interviews. But we have not violated any of the rules. Under Rule 3.6, we are allowed to speak publicly. about what information that's available to the public. We can get out there. My client is a rap performer. He's an artist. His reputation is being damaged by this trial. We're allowed to go out there and make the accurate assertion that he is innocent of this. So we've done nothing wrong. And I expect that the judge will rule against the state here. And by the way, one last thing, this is completely in keeping with the state's efforts throughout this trial to keep the public from seeing what's going on here. They've repeatedly tried to have witnesses not televised.
Now, we saw that, and I think Law&Crime has been at the forefront trying to make sure that the public does see the witnesses. This is a public trial. It's very important because there is a problem with crime in Atlanta. There is a gang problem. Let's not make no mistake about that. But how does this trial address that when it's supposed to be the leader, Young Thug, and quite frankly, I'm not sure if I'm sitting on the jury that I've heard anything that connects either your client or Young Thug to the really shall we say, egregious charge in the case is the one of murder?
Well, I think any unbiased observer who has watched this trial, and hopefully the jury as well, has seen that so far, after 100 days of testimony, almost 100 witnesses, this has been going on before the jury since November of 23, hasn't seen evidence that YSL is a gang, hasn't seen evidence of gang activity. They may claim we are some kind of hybrid gang, but that's just the nose of wax that the gang experts can twist any way they want to. So look at the evidence that's presented. I'm fine to stand on that and say the state has not shown that YSL is a gang or that there have been any racketeering activities.
Yeah, and I'm a former prosecutor, and actually I filed civil RICO charges on some cases, so I'm very familiar with the statute. Let's go back to the beginning of this trial. We all thought initially we're applauding Judge Glanville, except for those of us who were into the First Amendment on the rap lyrics, and that was the big issue, the rap lyrics that were going to be introduced. The rap lyrics have kind of gone by the wayside. What to you is the most egregious piece of evidence that the prosecution sought to put in that should have nothing to do with this trial? And then I'm going to ask you the other side, Doug. I'm going to ask you to be fair. What do you think is the most effective piece of evidence the prosecution has brought in that you have to rebut?
Okay. So I'm not going to let you take the rap lyrics and put those to the side, because I was one of the people that really led the fight against introducing those rap lyrics. And they have been used in the trial. I think they plan on continue to use them. And I think that's the most egregious. And where I come down on these rap lyrics, unless you can show some kind of a nexus with these lyrics, it's absolutely ridiculous to use them in the trial. So I think that's been the most egregious. The most effective, I think there was one day, and I can't remember the day in April, where the state listed for the jury a series of acts, a series of criminal actions that occurred in 2015. They put them up on a board and went one after the other. I don't believe they effectively tied our clients to those, but I think what they were trying to establish is that there was some type of a war going on. Not that I think that day was particularly effective, but I will give them that was probably their most effective day so far.
Yeah, and I won't throw the rap lyrics to the side. I would be singing Johnny Cash to you, but you don't want that because we all know about artists. What do you expect where do you expect the state to go next, and what do you expect the judge to rule on with regard to these motions?
Well, I really think, obviously, the state's going to oppose our motion for a mistrial. I expect, unless they're setting this up for a mistrial, because again, their case has been going so poorly that anyone can see. I think they've had at least a half a dozen of their key witnesses, their witnesses, that they had to impeach on the stand. So when that happens, as a former prosecutor, your case is not going well. So we'll see what happens with the mistrial. I think the judge should rule for a mistrial. I don't think the judge has much choice. And I hope that the judge can see that the reason for the mistrial is that the state has goaded us into making this request.
And Doug Weinstein, I'm going to let you wrap it up. Any final thoughts that you want to tell our viewers that I have not asked you before I let you go back and continue your defense of your client, Yak Gotti?
Thank you. I have no final comments except to thank all the media for continuing to cover this case. I think it's very helpful for the public to see what's going on in that courtroom.
Thank you, Doug. Law&Crime will be staying on this case. As you know, we have been committed to this case and will be committed to this case. Hope to see you in the courtroom. I hope at some point it's before I turn 90 that the case ends. Thank you very much.